If you see a doctor for a particular problem you're having, and now, weeks or months later, you now email the doctor, who then emails you and gives you medical advice, can that email communication be used to extend the time in which you have in order to file a lawsuit if that wrongdoing caused you injury? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, it can. Now, let me explain what I mean. In a medical malpractice case here in New York, you typically have only 2.5 years from the date of the wrongdoing in which to file a lawsuit against a private doctor or private hospital, a doctor whom you believe violated the basic standards of medical care, causing you harm and injury. Now, for municipal hospitals, for state hospitals, the time limit is much, much shorter. But now, what happens though if you are seeing and treating a doctor, and now instead of going back to the doctor for an office visit, the doctor said, listen, you can email me with any concerns you have. And now you go ahead and email the doctor replies to you and gives you certain advice in that email. You now follow that advice, and now you suffer injury because of information that was improper in that email or in other treatment. Can that extend the time in which you have to file a lawsuit? The answer is yes. As of today, July 8th, 2016, you should know that going forward, that may not be the case. The law may be changed. But as of today, that exists. There's a legal doctrine known as the continuous treatment rule. That says if you are still treating with the same doctor for the same problem and the same condition that you originally went to him for, your time to file a lawsuit will not begin to run until you have ended that relationship or the doctor has ended that relationship. Can you rely on that to assume that you have that additional time? Absolutely not. You cannot ever rely on that information. Instead, you have to assume that you only have the standard 2.5 years. Only by consulting with an attorney who reviews each and every page of your medical record, who asks you specifically, what did you complain about on each and every visit? What did the doctor do on each and every visit? What was the plan of treatment? Did they want you to come back? How did they want you to follow up? Did you follow up on your own? Was there a routine? What was expected of you? And what did you expect of the doctor? What did the doctor do? What did you do? All of these things go into determining whether or not your time to file your lawsuit may be extended up until the time that you last communicated with the doctor. There may be instances where those email communications did not represent continuous treatment, did not represent an ongoing doctor-patient relationship. So that's why you have to be very careful to assume that just because you're communicating by email or text with your doctor means that your time is automatically extended. You can't make that assumption. So the best way to know whether or not your case is actually valid, you have a timely matter, is to pick up the phone and call me. That's the best way to do it. This way I can ask you specific questions, evaluate whether or not you may have a valid case or a timely case, and then you know how to proceed forward. I realize you're watching this video and likely have questions about your own matter. Well, as long as your matter happened here in New York, I can answer those questions. So what I want you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Jerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Jerry Oginski. Have a fantastic day.